So friends, our exemption list continues, and in the last video we have already covered up to entry number 40. Now coming to exemption entry number 41, this is notification number 12 of 2017, and we are talking about exemptions in relation to services under GST. Entry number 41, this is upfront amount. By whatever name it is called, it may be called as premium or salami or cost or development charges, or by whatever name, but payable in respect of service by way of grant of long-term lease of 30 years or more. First is there is a lease. Number two, period is 30 years or more, and the purpose is it is for development of industry, of industrial plot or plot for development of infrastructure of financial business provided by state government, industrial development corporation or undertaking, or by any other entity in which at least 50% ownership is held by central government or state government. Then this exemption is available. So entry number 42, right? This is about leasing of industrial plots, and these are for either industry or infrastructure for financial services, right? And this leasing is for long period, and long period means 30 years or more, right? And this long term is having two things. One is upfront fee, and then lease rental. Now this upfront fees, whatever name it is called as, this is exempt, and this is taxable. Now this exemption is valid if it is given by state industrial development corporation or any other entity, but in this entity 50% or more ownership is held by central government or state government. So friend, this is the complete exemption. This talks about the exemption is in relation to leasing of industrial plot. The purpose is development of industry or infrastructure for financial services. The lease is granted for the long term, and for the long term lease the upfront fees is exempt, lease rental is taxable, right? So this you can highlight, that the lease rental which is payable on recurring basis, this upfront fees is exempt. Now upfront fees does not mean it is necessarily payable in the beginning. So it is payable in the beginning or it is payable in installment, that doesn't make a difference. But the upfront fees is exempt provided this lease is granted by State Industrial Development Corporation or any other entity in which at least 50% ownership is held by the central government or the state government. Then this exemption is available. So this is entry number 42. Now coming to entry number 43, this is services or this was 41. I'm sorry, this was 41. Now 42, it is no more relevant now because this is services provided by central government, state government, union territory or local authority by way of allowing a business entity to operate as a telecom service provider or use radio frequency spectrum during the period prior to 1st April 2016 on payment of license fees. So that period is already over, but quite possible the amount is due. So even if it is paid now, it will be exempt because the services are prior to 16, or these are prior to 1st April 16. Okay, so entry number 42, just put across on that, it is absolutely not relevant. Then comes number 43, this is service of leasing of assets. So rolling stock assets including wagon, coaches, locos, etc. by Indian Railway Finance Corporation to Indian Railways. So this exemption is very specific. It is only in relation to goods given on lease by Industrial Railway Finance Corporation to Indian Railways. So entry number 43. So this is leasing of goods or assets by Indian Railway Finance Corporation. So primarily this is set up for financing industrial railways or rather Indian railways, but this is also providing finance to others. Now this is divided in two parts. These are leasing of goods or assets. These are given to Indian Railways and to any other. Now supplying the goods on lease or rental or hire purchase, that is a business and this is also a supply. So that's why it becomes taxable. But exemption has been given when the assets or the goods are provided on lease by Indian Railway Finance Corporation to Indian Railways. So this is exempt. This is exempt. And the same entity giving the goods on lease to any other person, this is taxable. Right. So note that the leasing by Indian Railway Finance Corporation is exempt. Leasing by Indian Railway Finance Corporation is exempt only if the lease is given to Indian Railways. This is entry number 43. Now coming to entry number 44, this is services provided by an incubatee up to total turnover of 50 lakhs in a financial year subject to following conditions. The total turnover had not exceeded 50 lakhs rupees during the preceding financial year and a period of 3 years has not elapsed from the date of entering into agreement as an incubatee. So friends, for understanding this entry, you have to understand what is the meaning of incubatee, and the term incubatee is defined under clause number ZH. These all the definitions are at the end of the list. So now go to clause number ZH and let us refer what is incubatee. So incubatee means an entrepreneur located within the premises of technology business incubator or science and technology entrepreneurship park recognized by National Science and Technology Entrepreneurship Development Board of the Department of Science and Technology of India and who has entered into an agreement with the technology business incubator or science and technology entrepreneurship park to enable himself to develop and produce high-tech and innovative products. So entry number 43, or rather entry number 44, these are in relation to services by incubatee. Right? What is incubatee? That is in relation to definition under clause number ZH, right? Now this exemption is available only during first 3 years. Only during first 3 years. This is the limit, right? Now eligibility and what is the exemption? So this exemption is available to incubatee provided turnover during preceding financial year. Turnover during preceding financial year did not exceed rupees 50 lakhs. Right, now it is during first 3 years. So by chance if the turnover exceeds 50 lakhs in the first year itself, in the second year no exemption. Right, now in the first year itself exemption will always be there, because in the first year there is nothing in the preceding year. Right, so only during first year criteria is this. So this criteria becomes relevant for second year and third year. Exemption during current financial year, during current financial year, and this is up to turnover of rupees, slowly I am learning to write the symbol, 50 lakhs. So this is the exemption. There is an incubatee which is under an agreement for development of high-tech research and development products. During first 3 years, initial 3 years, not any 3 years, first 3 years, right? So during first 3 years, exemption is available. For availing the exemption, eligibility criteria is turnover during preceding 3 financial years has not exceeded 50 lakhs. And exemption is available during current financial year up to turnover rupees 50 lakhs. Okay. Now another entry similar to that is entry number 48. That is talking about the services provided by technology and entrepreneurship part. We'll come to that later. Now comes number 45. Entry number 45. Now in 45 we have different type of services. These are services by arbitral tribunal and services by lawyer, right? So lawyer thing again we will divide in two parts. So first we'll talk about the arbitral tribunal. This is services provided by arbitral tribunal to any person other than business and a business entity where the aggregate turnover to 20 lakhs or 10 lakhs in case of the special category in the preceding financial year, or the services given to the central government, state government, union territory, local authority, government authority or government entity, right? So arbitral services, these are exempt if these are given to any person not in relation to business. So having no connection with business. Now these services are given in relation to business entity provided aggregate turnover is below rupees 10 or 20 lakhs. If it is exceeding 10 lakhs or 20 lakhs, the same thing becomes taxable. If it is below, then this will not be taxable, right? So slightly bigger so you can read it properly. Then it further says, to the central government or state government or union territory or governmental authority or government entity. So any arbitral services to them, these are exempt. These, in nutshell, you can say, if the arbitral services are given in relation to a business entity whose aggregate turnover is exceeding the limit, then only those will be taxable. Now, as far as lawyer is concerned, for that I need to clear this. I hope you have taken a note, and by chance if you have not taken, press a pause button, but I need to clear this. Okay, so this is, I am clearing. As far as lawyer services are concerned, this is again divided in two parts. Individual lawyer or law firm. And here we have senior advocate. So actually only one difference you will observe, that in case of senior lawyer, even if services are given to another lawyer, those are also taxable. That is the major difference. So now coming to clause B, that says the partnership firm of advocates or individual as an advocate, but other than senior advocate, that's why I have classified it separately, by way of legal services to another advocate of firm or to any person other than business, and to a business entity whose turnover up to 20 lakhs in the preceding financial year, or to the government. So these are services given to a person but other than business, these are given to another lawyer or law firm, these are given to business entity but turnover below 10 or 20 lakhs, or given to central government, state government or union territory or governmental authority or government entity. All these are exempt. So here again you can say these are legal services given in relation to business if the turnover during preceding financial year of the business entity is exceeding that 10 lakhs or 20 lakhs, then those are taxable. In relation to senior advocate, this exemption is there, this exemption is not there, this is there, this is there. So in case of senior advocate, even if the services are given, legal services are given by him to another lawyer, those are also taxable. Right. So that is the only difference between senior advocate and other advocates. Now coming to entry number 46, right? I hope this is, you have already noted. This is important because this one is not an exempt. So here you can say that this will be taxable. Right. So in one chart we have covered entire entry number 45. Okay. Now we move to 46. This is services by a veterinary clinic in relation to health care of animals or birds. Now health care includes a diagnostic as well as a treatment both. So this is a veterinary clinic. Okay. Now 47, this says services provided by central government, state government, union territory, local authority by way of. Now earlier we talked about all the exemptions given by central government, state government, local authority as well as union territory. Those are exempt provided the value does not exceed 5,000 rupees. But that 5,000 limit is applicable in cases where services are not covered here. Here whatever we are going to talk about, even if the amount is more than 5,000, it is fully exempt. Right? So this is talking about registration required under any law for the time being in force. Services provided by central government, state government, union territory, local authority, where a registration required under any law. Now the best example is immovable property itself. In a given situation, registration charge itself can go up to 30,000 rupees in Mumbai. So that charges, we're not talking about the stamp duty, we're talking about the charges, registration charges payable. So that amount, even if it goes beyond the 5,000 rupees, since it is a requirement of law, this will be exempt. Registration of vehicle, that is again a requirement of law, registration fees can go beyond 5,000 rupees, still that will remain exempt. So registration required under any law, whatever be the fees, then that will not be subject to GST. Then number B, it is saying testing, calibration, safety check or certification relating to protection or safety of the workers, consumers or public at large, including fire license required under any law for the time being in force. So license fees required, testing fees required, calibration fees required, certification required. Now we have fire safety or certification, lift safety certification, lots of other certifications are needed. In case of taxi, meter requires a calibration and certification by RTO. So these are the examples where the certifications and calibrations are required by government authorities. So in that case also, whatever be the fees, whether below 5,000 or above 5,000, that will continue to be exempt. So in this entry we talked about two things. One is registration required under any law. So whether it is in relation to movable or in relation to immovable, registration fees will never be subject to GST. Number two, any fees payable for any certification or calibration, that will also, and if it is a requirement of law, that will also be fully exempt. So that is entry number 47. Now 48, this is in relation to technology parks. Entry number 44 talked about services by incubatee. Now this entry is in relation to services by the technology park. Now the technology park is providing services to the incubatee. So under this category, exemption is always full, no time period, no limit of turnover. So this says taxable services provided or to be provided by technology business incubator or a science and technology entrepreneurship park recognized by National Science and Technology Entrepreneurship Development Board of the Department of Science and Technology, Government of India, or bio incubator recognized by Biotechnology Industry Research Assistant Council under the Department of Biotechnology. So friend, this is the incubator. In entry number 44 we talked about the incubatee. So the person who is having the establishment in this area, his exemption is based on turnover of 50 lakh during preceding financial year up to turnover of 50 lakh during current year, and that is only for 3 years. Now this is talking about the incubator itself. Entry number 48 is talking about the incubator. If it is incubator is recognized under law, it is registered with the Department of Science and Technology, then exemption continues to be available in relation to services provided by them to the incubatee. Whatever be the services, all those services will remain exempt. Entry number 49. Now friends, we have few entries here which are just to be read and missed out. The number 49, this is services of by way of collecting or providing news by independent journalists, Press Trust of India and United News of India. Just read and omit. Number 50, services of public libraries by way of lending of the books, publications or other knowledgeable enhancing contents or material. Entry number 51, services provided by GST network to the central government, state government, union territory for implementation of GST. So this may be relevant. So you put an important mark on this. Entry number 52, this is talking about services by an organizer to any person in respect of a business exhibition held outside India. So this I need to explain. So this is entry number 52. when this becomes relevant. So entry number 52 becomes relevant when event organizer and participants are in India, but event is outside India. So friend, this is related to the place of supply to the large extent, because generally in relation to event, the place of supply is the place where the event is held. But in this situation, if the event is held outside India, then if the service provider and the recipient of service happen to be in India, then the place of service will be the place of recipient, so it will become taxable. But in this case, again I am dividing it in two parts. What type of event this is? This is in relation to business, and this is something else. Maybe a destination marriage arranged somewhere outside India. So the person, the parties to the wedding, those are in India. The event manager also in India. Situation is this, but the event is outside India. It will become taxable. So any other event, for example, destination wedding, this will be taxable. Why? Because of place of supply being in India. But business event, again this I am dividing in two parts. This is business exhibition, or this is some other event, say a business conference. So business conference, this will also be taxable. Under entry number 52, what is exempt? It is business exhibition held outside India, but subject to this, that the event organizer and the participant both are in India, but business exhibition is held outside India, then that will be exempt. And why the exemption? I said because of the provisions related to place of supply. So if this is the situation, the event organizer is in India, participant in India, then the place of supply will be the place of the recipient, that is the participant. So prima facie that becomes taxable, but exemption is there. So exemption I give you that if this is the situation, if it is an event other than business, it is always taxable. If it is in relation to business, so whether it is exhibition or some other event, if it is some other event, that is taxable. But if it is a business exhibition, that will be exempt, right? So this is entry number 52. Now coming to entry number 53. In entry number 53, if you remember the provisions of RCM, reverse charge mechanism under section 9, in that we said sponsorship services are under reverse charge mechanism, those are subject to tax. But if the sponsorship relates to sports, sponsorship relates to sporting event, and the sporting event has been organized by this body specified under this entry, then it is not taxable. So sponsorship, again I'll draw a chart for that. So here we'll put sponsorship. Now sponsorship, this is for sports or any other. Now in any other you can take example, any television show, any award function. Lots of cine awards are held, right? So this is fully taxable. There is no exemption for sponsorship of anything other than sports. So this will be taxable, and this is subject to RCM. And when it is a sporting event, the question is who has organized the event. This is organized by a specified body or any other. Now in any other, the example, the big example is BCCI. So this is again taxable. Right? Now if the sporting event is organized by the odd bodies which are listed in the entry, then that will be exempt. So the list you have to add herein, and this will be exempt. Right? So wherever we have added taxable, here you can add under RCM. Taxability will be there. So this is entry number 53. Now we move to entry number 53A. This is services by way of fumigation in a warehouse of agricultural produce. Fumigation services, you can say pest control services, given in a warehouse and in relation to agro produce. So this is again important parts we have to note down. Commonly it is referred as a pest control. Here it is mentioned as a fumigation services. These are 53A. These are fumigation services. Commonly referred as pest control services. These are given in a warehouse, and this is in relation to agro produce. In relation to agro produce. Right? Now all three when combined together, then only exemption is there. All three are combined. Right? So if the pest control services are generally not exempt, but the pest control services given in a warehouse, that is also not an exemption. But when third is combined, exemption becomes available. So pest control or fumigation services in a warehouse in relation to agro produce, then exemption is there, and this is entry number 53A. Next is entry number 54, and here we will cover up all services in relation to agriculture. So this is services relating to cultivation of plant and rearing of all forms of animals except rearing of horses. So rearing of horses is always taxable because that is a big money event. But it is about cultivation of plant and rearing of horses, but the purpose is either food or fuel or something like that. Rearing of horses, that is for a different purpose, that is a hobby, that is a big game, right? So that's where rearing of horses has been excluded from the list. So this says services relating to cultivation of plant and rearing of all forms of animal except rearing of horses for food, fiber, fuel, raw material or similar products or agricultural produce by way of. So all the services in relation to cultivation of plant or rearing of animals, but animals do not include horse rearing. Purpose is either food or fuel or fiber or raw material. And the activities are agricultural operations directly related to production of agricultural produce, including cultivation, harvesting, threshing, plant protection or testing. whatever services are needed in relation to cultivation. So whether it is harvesting or it is cutting or drying or it is pulverizing or whatever activity you call it, but these are indirectly in relation to agro produce, and services are in agricultural farm. Number B, supply of farm labor. Now supply of manpower is a taxable activity, but supply of farm labor, that is exempt here, right? So you cannot say supply of manpower is exempt. No, supply of manpower is taxable, but supply of farm labor is exempt under entry number 54. Number C, process carried out at the agricultural farm. Now this is not necessarily in the farm. If the similar activity is carried out even outside the farm, still the exemption continues to be available. So this is process carried out at the agricultural farm, including tending, pruning, cutting, harvesting, drying, cleaning, trimming, sun drying. So friends, I can suggest you all the activities in relation to agro produce, whatever you can remember, just add ing in the end. Right, whatever activity you can remember, everything is covered here, because it says tending, pruning, cutting, harvesting, drying, cleaning, trimming, sun drying, fumigating, curing, sorting, grading, cooling, or bulk packaging and such like operations. Underline the word bulk packaging or like operation which do not alter the essential characteristic of agricultural produce but make it more marketable for primary market. Whatever is required to be done for marketing or selling of the goods, but primary market is wholesale market. So whatever essential activity are required, but the impact of the activity should not have the impact of changing the characteristic. So that should continue to be recognized as an agricultural produce. If identity changes, then it will not be. Say for example tomato. Now tomato washing and packing, that is covered here, but converting the tomato into tomato ketchup, then tomato ketchup is no more an agricultural produce, right? So as long as services relate to tomato, everything will be exempt. Then in this further it says renting or leasing of agro machinery or the vacant land with or without a structure incidental to its use. Now renting or leasing of agro machinery, renting and leasing of assets, that is a supply. That's why that is also a taxable activity. But if it is an agro machinery in relation to agriculture, that will be exempt. Similarly, loading, unloading, packing, storage, warehousing of the agricultural produce, including the transportation. So transportation of agro produce, that is exempt in entry number 2021. Then all other activities, that is loading, unloading, packing, unpacking, warehousing, everything is exempt in entry number 54. Then agricultural extension services. These extension services are relating to, these are educating the farmer for growing or for promoting the agricultural produce. Then services by any agricultural produce marketing committee or board of services provided a commission agent for sale. Now these are the intermediary firms which facilitate marketing or selling of the agro produce. So these may be referred as agricultural produce marketing committee or board, or maybe any broker, not necessarily this committee or this board, any broker whosoever is doing the broking, but only in relation to agro produce. So if you go to the vegetable market in the morning when it is sold in bulk, there are intermediaries available. Those people are doing the broking services in relation to agro produce, right? Then their services are also not taxable. Then last is it is a repetition, actually services by way of fumigation, the warehouse of agricultural produce. For that we already have a separate entry in entry number 53A. So in nutshell you can say all the services in relation to agro produce, right? Whether services are given in the farmland or outside, that includes supply of manpower, supply of marketing, supply of selling, intermediary services, fumigation, loading, unloading, packing, unpacking, everything is covered in that. But essential important thing is basic nature of produce should not change, and that also includes agricultural extension services. So that is educating a farmer for promoting the agricultural produce. So that was entry number 54. Now 55, that is also having a relation to agriculture. This is saying carrying out intermediary production process as job work in relation to cultivation of plant and rearing of all forms of animal except rearing of horse for food, fiber, fuel, etc. So intermediary process, this is not the final process, right? So as we know that some of the activities are required in case of agricultural produce and required to be done outside the farm, and then goods are brought back and then further processing is done. So maybe conversion of paddy into rice, that activity is carried out outside the farm, that is exempt. Rice is brought back, further processing is done in the farm area, that will be, so that the process of conversion of paddy into rice, that will come in this category, intermediary process, and that will also be exempt. Number 56, this talks about service by way of slaughter of animal. I cannot explain this. Number 57, this is services by way of preconditioning, pre-cooling, ripening, waxing, retail packing, labeling of the fruits and vegetables which do not change or alter the essential nature. So this is, just understand, this is in relation to fruits and vegetables. All the things we are talking about in agro produce in general, these are two specific things regarding vegetables and fruits, because whatever is mentioned here, that is not required for all agro produce, because this is talking about preconditioning, pre-cooling, ripening, waxing, retail packing, etc. So these are not required for all agro produce, but these are required for vegetables and fruits. So when it is needed for these activities are also exempt. Now entry number 58, this is services provided by National Center for the Cold Chain Development under the Ministry of Agriculture Corporation for farmers' welfare by way of cold chain knowledge dissemination. Just read and omit. Number 59, services by foreign diplomatic missions. So foreign diplomatic missions established in India, so those are high commissions or those are embassies. What are the services given by them? Those are promoting the business tie-ups between and that country. Those are also facilitating the people from India to travel to that country, and for that visas are issued. So those are services for which they charge a fees, and any services by foreign diplomatic missions, those are fully exempt. Then next, number 60, this is services by specified organization in respect of religious pilgrimage facilitated by Government of India. So religious pilgrimage, but it is facilitated by Government of India. So Government of India facilitates only two. Number one, Haj Yatra. Number two, Mansarovar. So these two, right? But these should be through the properly recognized body. So either Hajj Committee, through the Hajj Committee, and the Mansarovar Yatra through the Kumaon Mandal. Then only exemption will be available. So any private party organizing a tour for the Mansarovar, no exemption. Private party organizing Hajj Yatra, no exemption. So this exemption, that first of all it has to be a religious pilgrimage, not any other tour. Religious pilgrimage. So only two, number one Hajj Yatra, number two Mansarovar, and that too if it is facilitated by Government of India. So Government of India facilitates these two religious tourism only through recognized bodies. Hajj Yatra through the Hajj Committee, for Mansarovar it is through the Kumaon Mandal. Then exemption is available. Then next is number 61. This says services provided by central government, state government, union territory, local authority by way of issuance of passport, visa, driving license, birth certificate, death certificate. These are need based. These are not compulsory for everyone. Death certificate, birth certificate, that is required by law, but issuance of the passport, issue of driving license, not a requirement of law. If you want to drive, you must have the driving license. If you want to travel abroad, you should have a passport. So these services, though not required by law, but if obtained, these are also fully exempt irrespective of charges. Earlier we talked about these services given by government but required by law. So that was any registration required under any law, any kind of certification or calibration required under law. So that is exempt. But these are not compulsorily required. That's why we have a separate entry. So any issue of driving license, issue of passport, issue of visa, as well as birth certificate, death certificate, these are fully exempt. Then number 62, services provided by central government, state government, union territory, local authority by way of tolerating non-performance of a contract. So whenever there is a contract with the government or local authority, there is a compensation clause in the contract. So when there is a non-performance on the part of the contractor, compensation is payable. So compensation may be predetermined, compensation may be determined later, but that is considered as a service by government by it is accepting non-performance, so that is tolerating non-performance. So whatever compensation is paid to the government, that is also exempt. The number 63, services provided by central government, state government, union territory, local authority by way of assignment of the right to use natural resources to an individual farmer. Underline the word individual farmer. But this is in relation to cultivation of plant and rearing of all forms of animal, but except rearing of horses. So these are the rights given to an individual farmer, either for cultivation of plant or for rearing of animals, but animal other than horses. And the purpose of this is either food or fuel or fiber or raw material, nothing other than that. So rights given to individual farmer for for using those natural resources. Number 64, services provided by the central government. So this is also limited purpose, so you can put across in number 64 actually. So services provided by the central government, state government, union territory, local authority by way of assignment of the right to use the natural resources where such right were assigned by the central government, state government, union territory authority, but before 1st April 2016. So why this exemption now? Reason is simple, that if the amount is payable in installments and that amount is payable now, still the exemption continues if the right was given prior to 1st April 2016. Then 65, this is services provided by the central government, state government, union territory by way of deputing officer any office time and after office hours or on a holiday for inspecting or container stuffing or such other duties in relation to import, export, cargo or payment of merchant overtime charges. So friends, under the Customs Act, the Customs Act simply says the activity of the import and export should be done under the supervision of the officer at the prescribed place within the prescribed time. But the services of the custom officers will be available on 24/7, 365 days, but on payment of extra charges. So those are the charges payable to the government as prescribed under law if the services of the custom officer are required outside the office hours, on a public holiday, always. So those services are also fully exempt. That is entry number 65. Right. So up to 65 in this video, and remaining all we will talk about in the next video.